Two matters have been called into the record. On April 15th, the people asked this court to sign an order to show cause related to allegations that the defendant had violated the gag order on 3 occasions. On April 18th, the people filed another order to show cause, alleging that the defendant had violated the gag order on 7 other occasions. The purpose of this hearing is to find out whether the defendant, Mr. Trump, should be held in contempt of court for one or all of these alleged violations. I believe it is the people's burden. I will hear you.
Thank you, Judge. Is it all right I'm going to use the podium?
Of course.
Judge, as an initial matter, I'm going to hand to the court and to counsel a set of documents. The documents numbered 1 through 10 are the alleged violations. They are all documents that were part of my affirmation, but just to make this part of the record of this proceeding, I am handing a copy to the court and a copy to counsel. There are also 4 additional documents that I may refer to in there separately. I would also note that there is a 9A. So one of the posts, post number 9, Exhibit 9, is the landing page of the Truth Social post, which is a newspaper article that the defendant posted. 9A is sort of a better version of that article, which is what you would see if you clicked on that article in Truth Social. It would blow it up into a better printout so that it is readable. Judge, each of the 10 posts that I just handed the court and counsel violate the order restricting extrajudicial statements that this court issued on April 1st. That order amended the court's initial order on March 26th of 2024. 8 of the violative posts were on the defendant's Truth Social account at Real Donald Trump. 2 of the posts were on his official campaign website, donaldjtrump.com. Each of them violates the court's April 1st order, which is a lawful order of this court. In that order, the court found that the types of extrajudicial statements at issue pose a very real threat to the integrity of the judicial proceedings by intimidating both defendants' direct targets, as well as others who may be called upon to participate in these proceedings, and who rightly fear being subject for vitriol and sort of the undertow effect that we worry about. Here, the defendant sought an emergency stay in the First Department, and I will talk a little bit more about that in a few minutes. That application was denied on April 9th, the application for the stay, and the next day the post at issue here started. Defendant has violated this order repeatedly, and he hasn't stopped. I just want to note for the record that yesterday, here in this building, right outside those doors, in a pen setup from which he has daily conducted press conferences on his way into and out of the courtroom, the defendant violated the order again on camera. He did it right here in the hallway outside. He said, among other things, they didn't say you building a building, and this is a transcript. They didn't say you building a building and called a payment to a lawyer because, as you know, Cohen is a lawyer. He represented a lot of people over the years. I am not the only one, and he wasn't very good in a lot of ways in terms of misrepresentation. But he represented a lot of people, but he puts in an invoice or whatever, a bill, and calls it a legal expense, and I got indicted for that. He later went on and said, and what are they going to look at? All the lies that Cohen did in the last trial. He got caught lying in the last trial. So he got caught lying, pure lying, and what are they going to look at? That? We will be filing another order to show cause for this violation later today. The court has warned the defendant. His attacks on witnesses clearly violate the order willfully and flagrantly. The court should now hold him in contempt for each of the 10 posts. The initial decision and order on March 26th, restricting extrajudicial statements, was issued after the people demonstrated a long history of attacks on all the participants in the judicial process here, and in other jurisdictions, witnesses, jurors, judges, lawyers, family members. No one is off limits to the defendant, and he can attack and seek to intimidate anyone he wants to in service to himself. On April 1st, the court issued a second order restricting the defendant's extrajudicial statements. That order, Your Honor, was issued because after the March 26th order, the defendant ratcheted up attacks on family members who were not covered by that March 26th order. Among other things, the April LST order prevents the defendant from making or directing others to make public statements about known or reasonably foreseeable witnesses concerning their potential participation in the investigation or in this criminal proceeding, and in a second relevant provision, prevents the defendant from making or directing others to make public statements about any prospective juror or any juror in this criminal proceeding. The defendant was warned that he would face sanctions under Judiciary Law 750, A, 3, and 751 if he violated. And here we are. Judge, I am going to go through the violations of the 10 posts that I just handed up. The first violation was on April 10th, 2024, at 10:07 a.m. The defendant published a post on his Truth Social account that reproduced a social media post by Michael Avenatti, the former lawyer of Stormy Daniels, who was later convicted of stealing from her. The Avenatti post stated, "We can't be hypocrites when it comes to the First Amendment. It is outrageous that Cohen and Daniels can do countless TV interviews, post on social, and make money on bogus documentaries, all by talking shit about Trump, but he's gagged and threatened with jail if he responds." To that, the defendant added in his own words, "Thank you to Michael Avenatti for revealing the truth about two sleazebags who have, with their lies and misrepresentations, cost our country dearly." The second post that same day,
If I can interrupt for 1 second, can you make the connection between that post and the conditions of the gag order specifically? So what you already read, making or directing others to make public statements about known or reasonably foreseeable witnesses concerning the potential participation in the investigation or in this criminal proceeding? Can you connect that for me?
well, the first part of that, clearly Stormy Daniels and Michael Cohen are known or reasonably foreseeable witnesses here. I think that's been clear for a long time. And by calling them sleazebags, by going after their credibility, I think that's all part of the plan for this trial. And there is no other reason to be talking about that than related to this. It's 5 days before we are going to be here to pick a jury. It's the defendant conditioning his followers related to this proceeding.
Thank you. I will be asking you the same question for each of the 10.
Thank you. April 10th, 2024 at 10:48 a.m., the defendant published a post on his Truth Social account that contained a picture of a document, and that document, by the way, will be at issue in this case. The document was entitled Official Statement of Stormy Daniels, dated January 30th, 2018, which refers to facts that are directly at issue here. The defendant accompanied the picture with his own statement, "Lock what was just found from a fake news reporter." Again, Judge, that is a document with respect to the first subsection in the order. It is a document that relates to a reasonably foreseeable witness in this proceeding. It is a document that relates, specifically, to things that she'll testify about in this proceeding. And so, I don't think there is any other interpretation of that post, again posted 5 days before jury selection, than that it relates to this proceeding. On April 13th, 2024, at 12:56 p.m., the defendant posted a post on his Truth Social account and stated, "Has Mark Pomerantz been prosecuted for his terrible acts in and out of the DA's office? Has disgraced attorney and felon Michael Cohen been prosecuted for lying? Only Trump people get prosecuted by this judge and these thugs. A dark day for our country. MAGA 2024. Here again, Judge, Michael Cohen is a reasonably foreseeable witness. Throughout the pendency of this case, defendant and others have tried to make Mark Pomerantz somehow an issue in this case. This is, again, going after Michael Cohen's credibility, which is a recurring theme in these posts, and frankly, was a theme yesterday in the opening statement for this case. And so, I think it's pretty clear now that we are 2 days before jury selection, and the defendant is again going after Michael Cohen. On April 15th, 2024 at 9:12 a.m., and this is while the defendant was likely in the courthouse, the defendant published a post on his Truth Social account that stated, "A serial perjurer will try to prove an old misdemeanor against Trump in an embarrassment for the New York legal system." The post contained a link to an article in the New York Post, clearly a reference to Michael Cohen, clearly a reference to this proceeding. And so I think, again, that link to the order is pretty clear with respect to this post. That same day, about an hour and 15 minutes later, the defendant posted the same post again on his Truth Social account. And for the same reasons, it is clearly related to these proceedings and to a reasonably foreseeable witness in the case. Again, that same day, April 15th, 2024, on his official campaign website, just to make sure the word fully got out, the defendant published a link to an article from the New York Post with the following introduction, ICUAMT, which my understanding is it means in case you missed it, and then a colon, and then the same link that he had posted twice previously that day. A serial perjurer will try to prove an old misdemeanor against Trump in an embarrassment for the New York legal system. Again, specific reference both to this proceeding and to a reasonably foreseeable witness in the case. The next day, on April 16th, 2024, and we are on Big Shib 7 that I handed up, so I should have been giving those numbers as I went along. On April 16th, 2024, 1:50 in the afternoon, the defendant published a post on his Truth Social account that stated, "It's again," the same post that we have just been referring to, and it contained the same link to the article. That same day, on his official campaign website, he again posted the, "In case you missed it," with the link to the serial perjurer, "Will try to prove an old misdemeanor against Trump in an embarrassment to the New York legal system." Again, those are so clearly related to a reasonably foreseeable witness in this proceeding. On April 16th, 7:09 p.m., the other thing to keep in mind, and I know Your Honor knows this, I'm just going to say it for the record, this is while we are on trial. The trial has now begun. On April 16th at 7:09 p.m., the defendant published a post on his Truth Social account that contained an article attacking the testimony of Michael Cohen. The article had a picture of Michael Cohen with the headline, "No, Cohen's guilty pleas does not prove Trump committed campaign finance crimes." The entire article was embedded in the post. And again, that's what I handed up as 9A. If you clicked on various parts of the article, the particular page of the article would come up in a more readable form. The whole thing was visible when you clicked into Truth, and again, reasonably foreseeable witness, direct reference to this proceeding, very clear link to the order that this court issued on April 1s. The next day, and this was last Wednesday, April 6th, 17th, and again, this is a very troubling post at PM, the defendant published a post on his Truth Social account that stated, "They are catching undercover liberal activists lying to the judge in order to get on the Trump jury." I want to give the court a little bit of context for that truth, and that is a quote. That whole thing is in quotation marks. It's attributed to somebody named Jesse Waters. On that day, last Wednesday, there was a segment on a Fox News show called At 5 that airs at 5 o'clock in the afternoon. On that show, Jesse Waters, who is one of the commentators, spoke about the jurors who had been seated or were being interviewed in this case in a derogatory way. Mr. Waters said the first part of what Mr. Trump posted. He said the first part in order to get on the Trump jury. Now, Mr. Waters may have said things like, in order to get on the Trump jury, later in that episode or later that night when he has another show at 8 o'clock, but he didn't say it at 5:08 on his show. And this post came at 6, about 30 minutes later, give or take.
What exactly did he say?
So he said, what Mr. Waters said was, they are catching undercover liberal activists lying to the judge, period. What was in the quotation on the defendant's truth was, they are catching undercover liberal activists lying to the judge in order to get on the Trump jury. So it is a hybrid of something somebody else said together with something the defendant apparently added on his own. I think the link to the jurors in this case, to this proceeding, I think it's very clearly a violation of your order on April 1st, and so that deals with that. The other piece I want to add to that is if you, Tam, sure, again, I am sure you remember, but for the record, this was last Wednesday evening that this was going on, and Mr. Waters in his segment was giving lots of details about the various jurors. The next day was the day Juror 2 came in and said, I don't think I can be on this anymore because of publicity and things she was hearing from friends and acquaintances and everything else, so we ended up losing a juror. What happened here is precisely what this order was designed to prevent, and this defendant doesn't care. The burden here, Judge, is on us. And Judge, that's the 10 posts. I don't know if you have any questions specifically about those, or I was going to move.
You can move on.
The burden here is on us to show the existence of a lawful order expressing an unequivocal mandate, a violation of the order, and that the violation was made with knowledge and is willful beyond a reasonable doubt. The court's order of April is clear and unequivocal, and it is lawful. It has been challenged a couple of times here, and it was challenged in the first department. A stay was denied. One of the bases for issuing a stay would be possibility or likelihood of success. That stay was denied. There is ongoing litigation there, but right now this is a lawful order in front of this court. He violates the order when he posts about known witnesses or reasonably foreseeable witnesses concerning their participation in this criminal proceeding, and he violates the order when he posts about a juror or prospective juror. And, Judge, that language is a broad prohibition with respect to the jurors about statements about the jury here. It is not limited to a statement about a particularly identifiable juror. Counsel in their papers inserts the word individual in the filing on page 7 in an effort to argue that this provision is ambiguous. The order is clear, notwithstanding the defendant's willingness to make arguments that conflict with the facts and at times with each other. And the clarity is stark with respect to this provision related to jurors, particularly when contrasted to the more specific language that modifies witnesses, the court and Danny personnel. Judge, I would just refer to some of the language, and I won't read it. Some of the language in the court's April 1st order, talking about why it is so important to issue that order now based on the defendant's history, based on this proceeding, and based on what was going on. There is no doubt that this defendant made these statements. And I just want to talk a little bit more about the back and forth on that last post, the 10th post with Jesse Waters, because I think those two, the defendant's willfulness in these posts, defendant took something that Jesse Waters said, added to it, and posted it. And it came from a segment specifically discussing juror profiles in this case. He did it about 40 minutes after Jesse Waters said part of the statement. To me, that shows very clear deliberation and willfulness in making the post. All of the posts here are made concerning this criminal proceeding. We know that from the proximity. We know that from the words. We know that because they are consistent with the defense in this case, as outlined in counsel's opening yesterday. It's very clear that they relate to this case. I'm not sure how there could be a straight-faced argument that these posts, all within the last 12 days or so, some of them echoed in counsel's opening yesterday, relate to anything other than this criminal proceeding. Throwing MAGA into a post doesn't make it political. It may make it more ominous. Defendant's 10 posts at issue one day are willful violations of the court's order on April ist. The defendant knows the terms of the April ist order. He has repeatedly complained about the order on his social media account, including, among others, and I handed the posts up in the packet that I handed up of the 10 violations. There is a post from April 2nd, from April 6th, and from April 10th and 11th.
Is that Exhibits 12, 13, and 14?
Yes, Exhibit 12 is April 2nd, Exhibit 13 is April 6th, Exhibit 14 is April 10th, and Exhibit 15 is actually a screenshot that would appear on the Truth Social page. If you clicked it, it is a video in which defendant is actually speaking about the gag order and the fact that kind of what he says is he is gagged, but he is referring to it. He refers to the order's restrictions and attacks the court as conflicted. The defendant has engaged in multiple rounds of briefing involving the April 1st order and its earlier version, the March 26th order, including filings in this court, and in the appellate division, up to and including his response to this order to show cause on Friday, on the 19th. In each, the defendant has engaged in details with the order-specific directives. His appellate division filing specifically criticizes and seeks to prohibit enforcement of the April 1st order's restrictions on his extrajudicial statements regarding Michael Cohen and Stormy Daniels. In paragraph 9 of the defendant's verified Article 78 petition filed by counsel, they complain that the article, that the April ist order forbids the defendant from responding to so-called attacks by Michael Cohen and Stormy Daniels. And yet, that's part of their argument here, is that he is allowed to respond to these attacks. So in the first department, they are saying he's forbidden. He knows. He is forbidden. That's what the order says. And yet, they want to come now and claim and muddy the waters and say, Judge, well, we can respond to attacks. There is no provision in this order for responding to attacks. They have repeatedly cited to a line in which the court does say that the defendant can respond to political attacks and try to morph them into a massive exception to the order, which it is not, and it is clearly not, and the court should not be swayed by that. I would also just note that this is not the first time there have been filings in different courts with inconsistent representations or assertions, and I submit that they can't be taken seriously. When we examine the defendant's words and his actions, it is clear that he knows about the order. He knows what he is not allowed to do, and he does it anyway. There can't be any question that he is aware of what the order requires, and that knowledge alone indicates that his disobedience of the order is willful, is intentional. Even if his asserted ability to respond to attacks can be used as political or based in fact on the order, and it is not. There is no indication that his claim that he is responding to attacks is anything more than an after-the-facts justification for his contumacious behavior. It is not clear at all that he was aware of the posts he claims he was responding to at the time he made the post that violates the court's order. Nothing on the face of the post indicates that. By his logic, if someone covered by the order says something mean or not nice about him, he can respond because the attack is political, I suppose, because by talking about the defendant, the speaker is a public figure, or because the defendant is running for office. Again, it makes no sense. He says whatever he needs to say to get the results that he wants. It's tortured at best, and would eviscerate the clear language and meaning of this order if the court were to adopt that. The court and the people have made clear that the April 1st order leaves the defendant substantial room to engage in speech about this criminal proceeding, including criticisms of the court and district attorney. The defendant has shown his ability to understand the significant leeway left to him by making multiple social media posts and other public statements that criticize the criminal trial without violating the April 1st order. By going beyond those criticisms and launching specific separate attacks on two witnesses, and by attacking prospective jurors or juror, the defendant is nothing less than knowingly and willfully, that is intentionally, breaching the crystal clear, unequivocal lines set by this court in the April 1st order to protect the integrity of this proceeding. I'm just going to talk a little bit about another argument that the defendant made in his papers, where he claims that what he calls reposts are not his statements. In fact, some of his most dangerous statements, including one we brought to the court's attention as early as arraignments last year, that photo of the defendant holding the bat at the head of the district attorney, are what he wants to carve out of the order by calling them reposts. That flies in the face of common sense, and I'm going to draw an analogy which is not perfect, but I think is helpful. New York defamation law has made clear for over 100 years that one who repeats or otherwise republishes a defamatory matter is subject to liability as if he had originally published it. That's Gurazzi versus Probst, 15 New York 3rd, 336, and I can hand up copies if you like. I will do that at the end.
Sure.
Here we are dealing with a court order that specifically prohibits certain types of extrajudicial statements, and that clearly includes posts on defendant's Truth Social account and on his campaign website, whether he is the original author or posting the words of another. And as the court noted the other day, the law is clear that a party may not challenge a court's order by violating it. Your Honor, the judiciary law authorizes the court to impose a fine not exceeding $1,000 or to sentence the contemner to no more than 30 days jail or both in the discretion of the court. That is in Judiciary Law 751, and that's for each finding of contempt. We are not yet seeking an incarceratory penalty. The defendant seems to be angling for that. For today, for these 10 violations of this court's April 1st order, we are asking the court to impose the maximum number, $1, 1,000 fine for each of the 10 violations. We are also asking the court to order the defendant to remove all 10 offending posts, 8 from his Truth Social account and 2 from his campaign website, to take those down. Finally, for the court to again warn the defendant that this conduct will not be tolerated and remind him that incarceration is an option should it be necessary. The defendant is having his day in court. Unfortunately, he is still doing everything he can to undermine this process. It has to stop. A finding of criminal contempt, imposition of sanctions, and stark warnings from this court are the minimum remedies necessary to try to stop the defendant from engaging in this behavior. Thank you.
Thank you, Mr. Conroy. Counsel?
Thank you, Your Honor. There is, just to set the record very straight and clear, President Trump does, in fact, know what the gag order allows him to do and not allow him to do, and there was absolutely no willful violation of the gag order in the 10 posts, and released by the campaign that the people just discussed. There is no dispute that President Trump is facing a barrage of political attacks from all sides, including from the 2 witnesses who are referenced in the early posts. And I am going to separate, Your Honor, if I can, the reposts from the first round of alleged violations involving the Avenatti comment and the comment regarding Mr. Cohen not being convicted of perjury and the comments about Ms. Clifford and Mr. Cohen. Okay, those comments, those 3 posts, were in direct response to comments made by these witnesses, not about these criminal proceedings, Your Honor, not about their testimony at the witness stand, and President Trump's comments back to them was not about their testimony from the witness stand.
When you say these 3 posts, just so I can follow them, can we adopt the number used by the prosecution? If you can refer me to this, what you are talking about.
The first was a repost from President Trump's Truth Social regarding Mr. Avenatti, commenting about the hypocrisy of the gag order and making the point that, which is true, that the witnesses themselves can constantly comment about whatever they want. They are not gagged, and President Trump, in theory, cannot respond. Now, as we put in our papers, and the people don't contest except to say there is no evidence from the truths that President Trump knew about these, Michael Cohen directly responded to this comment by Avenatti, politically, not about the testimony, not about what he is going to say in court. And so, President Trump.
Do you have that? Do you have a copy of that?
Your Honor, it's in our papers on page 4. I can read it into the record, Your Honor.
Sure, if you can tell me what time that was.
Sure. 1/4 is the original post from somebody who says, "Seems to me that Avenatti was thrown a Hail Mary on a pardon should the Orange Menace get elected." Mr. Cohen responds, he will be very disappointed as Trump will never pardon him because he doesn't care about him anyway. So, obviously, pardon is political. It has nothing to do with this case, Your Honor. And so, when President Trump comments about what Mr. Avenatti is saying, complaining about the gag order, and a comment that Mr. Cohen has made about it, that's political. We is allowed to respond to political attacks.
I want to make sure I'm following you. Going back to number 1, Mr. Avenatti's post was at 10:07 a.m. Can you confirm what time Mr. Cohen's post was?
I don't have that in front of me.
It's just been handed to me, so Mr. Cohen's post, I believe, was at 9:21. So that would precede Mr. Avenatti's post.
Well, Your Honor, to be clear, Mr. Avenatti had been saying things like this publicly. There have been news articles about it that he had been saying, so he has somebody on the outside, a federal person, that is pushing articles and Your Honor, there is no dispute that Mr. Cohen has repeatedly talked about the fact that, again, not for having to do with his testimony about how President Trump acted with respect to pardons while in office.
I want to take one at a time, otherwise it's going to get really confusing. Let's take number 1, what I see as Mr. Cohen's post at 9:21. Mr. Avenatti's response appears to be at 10:07, or is that when it was reposted by Mr. Trump?
Yes, correct.
It was reposted by Mr. Trump?
I believe that's correct.
And it's your position that what makes this political is the reference of being pardoned.
Well, 2 things make it political. At the reference to be pardoned, but also President Trump writes in response to what Mr. Avenatti is saying. Nothing about this case, Your Honor, but that they can do TV interviews, post on social, make money, have documentaries, all while talking about President Trump. But he is gagged and threatened with jail if he responds. Then again, the social media posts he is referring to from these witnesses, the documentaries he is referring to from these witnesses, the money that they have made because of President Trump, the TV interviews, all of those things, Your Honor, while they certainly bring up the fact that they are testifying, they are talking about their very strong dislike of President Trump, their very strong desire for him not to win the election, and for him to no longer be in power.
Let's stick with what was actually said. I don't want to get into interpreting things. Let's stick with what was actually said. Going back to number 1, what is it about Mr. Cohen's post that makes it political?
Well, Mr. Cohen's post talks about whether Mr. Avenatti will get a pardon.
So the pardon is what makes it political?
Of course. Yes, Your Honor. Your Honor says you don't want to interpret or read into it, but we have to be able to have some inference for what Mr. Avenatti means when he is saying that.
Have you spoken with Mr. Avenatti about what he means?
No, of course no.
How can you interpret what he means when you haven't spoken to him?
From his words. His words say, he doesn't talk about what Mr. Avenatti believes they are going to say on this witness stand, or what happened in the charged conduct. It says what they have been doing on TV, the social media posts, and on documentaries.
I just want to make sure I understand. You believe that everything that Mr. Avenatti said does not relate to the trial, but that the use of the word pardon by Mr. Cohen does make it political, and in a sense, authorize your client to respond.
Not just the word pardon, but yes, the word pardon too. But Judge, it's everything. It just can't be a single word. When Mr. President Trump is responding to these attacks,
when your client is violating the gag order, I expect more than one word.
Your Honor, we are here to determine...
I haven't determined anything yet. I am simply responding to what you are saying. You are suggesting that merely the use of the word pardon is sufficient to allow your client to violate a gag order.
No, that's absolutely not what we are saying, Your Honor. Absolutely not. What we are saying is, A, President Trump is allowed to respond to political attacks. B, and more significantly, if he is talking about witnesses, it can't have anything to do with these proceedings. Judge, remember why that exists. The reason why this restrictive language in your order exists is from the decor of appeals. As Your Honor will recall, the original gag order.
I remember.
I don't mean to relive that, but that's the point, is that in the D.C. Circuit, in reaching its decision, addressed why we are here today, and said that there will be times when it is difficult to determine whether a statement concerns a witness's potential participation in the investigation, or the criminal proceeding, or a response to an attack. Political.
That's why I am going to be asking you, in the same way I asked the people, for each one of their exhibits, to explain to me what made it political. I am going to ask to you, after each exhibit, what precisely is it that your client is responding to? Lead me to the attack he is directly responding to in each one of these.
He is responding to the fact that that Mr. Cohen has repeatedly talked about his qualities and candidacy for office of the president.
There is no specific post that you are referring to?
No.
It is a repeated post?
That's where it refers to the actual language of the gag order, which is that so long as the discussion and comment isn't about the participation in this, it cannot be the mere time, meaning because it is a couple of days before the trial starts, that's it, beyond a reasonable doubt, that's willful. Right, meaning, what I mean by that is Mr. Cohen in particularly, and also Ms. Daniels, have ramped up their political attacks and their attacks on him as a candidate in the weeks leading up to the trial as well.
It is the timing that has me a little bit confused. You referred to repeated attacks. Yet this first exhibit didn't happen until, was it the day after the matter was brought at the appellate division? So your client waited until after, the day after the matter was brought to the appellate division and the stay was denied, to decide if he would respond not to a recent attack, but to a series of attacks. Can you understand why I am curious about that, rather than responding a day before or 2 days before or 3 days before?
The timing of the response, Your Honor, appreciating it, was a day after the appellate division. When we were in the appellate division, they were alluding to today. One of our main arguments was that we would be here for this kind of issue, that there was something ambiguous about what it would mean to attack a witness, about the foreseeable witness, but, Your Honor, no criminal proceeding of why they are here. And so, Your Honor, I appreciate the question about the timing, but the timing is just the timing. And, President Trump chose repeatedly, all day, virtually 7 days a week, Your Honor. And by the way, well, we will get to the reposts in a moment, Your Honor, but the same is true for...
Can we go on to exhibit number 2?
Yes, Your Honor. So, again, this is a document, as the court knows, that's been in the public record and part of the public dialogue for many, many years, and I do not dispute the people's position that this document will be discussed at this trial, potentially. No dispute there, but again, you have a witness who is not talking about her testimony here, but talking about President Trump's qualifications for office and whether he should be president.
This was a response to what specific attack?
Well, there have been, again...
You pulled this out, and this is 6 years old when he pulled it out. So I am assuming that there must have been a very recent attack to cause him to pull out a document that's 6 years old and was going to be used at trial.
It's not that it was pulled out. It is a public document. It's publicly available, Judge.
It says, look what was just found. Was that just found?
No, absolutely not.
Dollaro, that's not true. That's not true?
That is not true. I don't think anybody thinks that's true. Everybody has seen the document for years and years.
Whether somebody thinks it is true or not, I need to clarify, and I need to understand what I am dealing with.
As we note in our papers, Your Honor, this is a document that is available to the public for years and years. And yes, President Trump chose the words, "Look what we just found." It's true. It is a communication to the folks that he is trying to message to. Again, not about the witness's testimony at trial, but about her credibility. There is not a link between this document.
Credibility really doesn't matter a whole lot on this unless she's taking the stand at trial, right?
Judge, that's not true. This is not true. Sure, her credibility will be at issue at this trial. Her credibility, when she's broadcasting to all of her followers on Twitter and talking to the press and having documentaries, her credibility matters. It does matter in this courtroom, but he is running for president. He has to be able to respond to that.
All right, so that was exhibit number 2. I asked again what specifically he was responding to. I didn't get an answer to.
I did answer you. Yes, I will answer you again. There was repeated specific.
Give me one. That's not specific. Give me one that he was responding to here.
Yes, Your Honor. So there was. Don't have a particular tweet that it was responding to. What we included in our papers, Your Honor, is an example, in addition to the documentary that came out, which is very critical and again, Your Honor, says that timing matters, right? Why?
I am asking the questions. Okay. I am going to decide whether your client is in contempt or not, so please don't turn it around. What I do see is I keep asking you over and over again for a specific example, and I am not getting an answer. And it's now almost 10 o'clock. The jurors are going to be here at 11 o'clock. I don't want to keep them waiting. So we are only up to exhibit number 2.
The people got to speak as long as they wanted to.
The people were answering my questions. It's almost 10:30. We are only up to exhibit number 2. Let's go to exhibit number 3 and tell me what he was responding to in exhibit number 3.
Your Honor, exhibit 3 has nothing to do with this investigation. It's a complaint about the system, which President Trump is completely entitled to complain about. And the fact that there is a key witness in this case who is in prison right now for lying at a proceeding that Mr. Cohen also lied at. And again, it has nothing to do with his testimony here.
He or his comrades? Make the connection to what he is responding to in exhibit number 3 when he is referring to Mark Pomerantz.
He's asking whether Mr. Pomerantz has been prosecuted for violating grand jury secrecy rules.
Why? Pardon me, why? Why does he have to bring up a witness he knows is a witness?
No, Mr. Pomerantz is not a witness.
He is not on the witness list.
No, I believe they are complaining about this one. Your Honor, the third line down, has disgraced attorney and felon Michael Cohen been prosecuted for lying. That is what I was addressing when I said that the objection and the statement there has nothing to do with this case. It has to do with the system and the fact that President Trump very strongly believes that the people should have prosecuted Mr. Cohen for lying, just like they prosecuted.
So he is attacking Mr. Michael Cohen's credibility just like he was attacking Stormy Daniels' credibility.
No, he's attacking the people and system for not prosecuting Mr. Cohen for lying. Right. Look, that's been a theme that President Trump talked about repeatedly and for good reason. It seems that there are two systems of justice. Mr. Weisselberg is in prison and Mr. Cohen is going to be a witness. That's attacking the system, not Mr. Cohen, and it certainly...
Except that he makes the connection. The name that you refer to is Mr. Cohen.
It does mention him by name. That's not prohibited by Your Honor's gag order.
Using the name is not prohibited. Making the connection to the trial is prohibited. Making a connection to the witness or the prospective jurors for the trial makes it prohibited.
I am sorry. I didn't mean to interrupt. We're not making a connection to this trial at all. It says disgraced attorney Michael Cohen has been prosecuted for lying. That has nothing to do with this trial. That is a question about whether he was prosecuted for his testimony in another case several months ago.
What caused that response? What was he responding to?
Well, he is responding to the fact that he is extremely frustrated with the two systems of justice that are happening in this courtroom, and he is entitled to respond to this. Whereupon, principal court reporter Susan Pierce Bates was relived by senior court reporter Lisa Kramsky. The core two systems of justice in this courtroom, is that what you're saying? That's what his message is, Your Honor, that Mr. Weisselberg is in prison and Mr. Cohen is not. That's not the first time that this has been said.
It's not.
No, it's not. And Judge, as Your Honor has made plain, that's fair game. And as the law may explain and the Constitution may explain, that's fair game for President Trump to complain about. And to focus on the reposts now, if Your Honor wants to move to the reposts?
We can.
Okay.
Just before we get to the reposts, when we get to each specific repost, just tell me what number you are referring to.
I'm referring to the remainder, many of them. Just 2. The same posts just kind of reworked on a different, either on Truth or through the campaign. Judge, this goes directly to the willfulness that Your Honor has to find beyond a reasonable doubt for President Trump. There have been multiple reposts since Your Honor has imposed the gag order, and then the second gag order that the people have not complained about. And we mentioned a few in our papers involving the recusal motion and things that if the people felt or the court felt that a repost was a violation, it's not a statement by President Trump. And so, Judge, it's that.
No, I read that in your papers and I actually want to respond to that.
Please.
That suggests that somehow because the people or the court do not take action for every single violation that the gag order is waived. That's just silly.
That's absolutely not what we're saying.
No, it is what you're saying. No, first of all, you suggested that the court should do something. I think you understand the difference between what is a summary criminal contempt and what is not a summary criminal contempt. Unless that occurs in my presence before me, the court is not going to bring an action, okay? As far as why the people chose to implore some and not others, that's their business. But that doesn't negate the validity of the gag order.
And, Your Honor, if that came out in our papers, that is absolutely not our position. Our position is that Your Honor has to find a willful violation beyond a reasonable doubt. And it is certainly appropriate for the court to take into consideration whether President Trump's conduct was willful beyond a reasonable doubt. The fact that, when he reposted the ones, Exhibits 3 through 10, the fact that he had reposted many others and the people had not brought an order to show cause, it's not making a mockery of the gag order, Your Honor. It's a close call. The court. Well, what is it if your argument is not that somehow the validity of the gag order is waived? Then what is your argument? Because that's what it sounds like to me. No, because the posts...
No, the people did not bring an order to show cause for certain alleged violations. Therefore, he's allowed to violate whenever he wants?
Your Honor, the gag order prevents him or him causing somebody to violate the terms, reposting an article from a news site or from a news program or, a New York Post article or the articles that are in Exhibits 3 through 10. We don't believe are a violation of the gag order.
All right, so let's talk about that. That I want to talk about.
Okay.
So tell me what case law you have to support that.
I don't have any case law to support that, but it's just common sense, Your Honor. How can it be that President Trump is prohibited from violating the gag order through his words or by causing another person to say something that he was saying?
All right.
Which is a big difference under the First Amendment under the Constitution.
All right. Where does it say that? Give me the case law.
Your Honor, there is none. I don't believe...
What I'm asking you, when we are talking about these reposts, how does it get there? How does it get onto your client's Truth Social account? I post something, and I post it on my account, and then it winds up on your client's account. How does it get there?
There is a group of folks that work with President Trump that, when they see articles that they believe President Trump's audience should read, there is a mechanism. I'm not...
What is the mechanism?
So I believe you click on it and you do something to repost it on President Trump's feed.
It requires some sort of action?
Of course, yes.
It's not as if I'm looking for the decision that I read yesterday. It's not passive. There is case law that talks about the difference between passive conduct and what we're describing. Passive conduct would be if someone makes a post and it somehow winds up in your client's account without him or anybody else doing anything.
That's not our position.
No, it's not your position, which means that someone had to do something.
Yes.
Okay. So calling it a repost and suggesting that because somebody else wrote it and then miraculously it appears in your client's account that therefore your client can wash his hands of it, you said it's just common sense. I say it's just...
It's not. Judge, we are not saying... I'm not asking that President Trump wash his hands of it. The question is whether it's a violation. If it's unambiguously a willful violation of the gag order to take a news article that appears in whatever publication it's from and post it, as opposed to using your own words.
So it's your client's position that when he was reposting these things, he was not violating the gag order?
Correct.
So how do I know that that's his position because you are telling me?
Well, Your Honor, I think that...
Are you testifying under oath that that's his position?
Your Honor, I'm not testifying under oath. I'm making argument, Your Honor.
Well, it's your client's position that at the time that he reposted anything to one of his accounts, he did not believe that he was violating the gag order. I would like to hear that.
Your Honor?
I would like to hear that. Or do you want me to accept it just because you're saying it?
No, I don't expect you to accept it because I'm just saying that. But what I would like you to look at here, Your Honor, is that there is a history of posting and reposting that have gone unchecked. And I agree with you that the people have a right to choose when they want to and when they don't want to bring an order to show cause. But that certainly goes to whether the court can find that it's willful, the fact that President Trump hasn't done it.
I just want to make you aware that the people presented 10 exhibits. They indicated what their case law is. I understand what your position. The people have presented that case law. You have no obligation, of course, but you have presented nothing.
No, Your Honor, we are in the middle of a criminal trial, and you are asking whether I should put President Trump on the stand. Is that the question?
Well, I'm just telling you that you have presented nothing. I have asked you 8 or 9 times, show me the exact post that he was responding to, and you have been unable to do that even once. Let me ask you about Exhibit 10. Pause. So this is Exhibit 10. It was posted on April 17th at 6 p.m., and it says, in quotes, "They are catching undercover liberal activists lying to the judge in order to get on the Trump jury." Closed quote. And then it's attributed to Jesse Waters. Is that, in fact, what Mr. Waters said?
He said, "They are catching undercover liberal activists lying to the judge." And then not. At the time, I don't believe he said in order to get on the Trump jury.
Well, at the time that he reposted this, he had not said that.
Correct.
So your client manipulated what was said and put it in quotes. Am I right?
I wouldn't use the word manipulation, Your Honor, but the rest of the quote is not part of the quote.
Okay, my other question is, this is not a repost at all.
No.
No. This is something that was said on TV, and your client had to type it out. He had to sit there, use the quotation marks, the shift key, and type everything out, and then add those additional words. So your argument that these are reposts, and therefore they are not a violation, that does not apply to Exhibit number 10, is it?
Number 10 is not a repost. Agreed.
So what is your argument as to Exhibit 10?
Judge, the argument as to Exhibit 10, it's ambiguous whether this statement violates the gag order. Again, we have to find a willful violation of the gag order beyond a reasonable doubt. And President Trump voicing his view that there were liberal activists trying to get on this jury is not calling on a particular juror. It's not in any way trying to threaten or intimidate jurors. It just isn't, Your Honor. I mean, and there is not. It's tough to read, especially because that night, Your Honor, remember we are talking about what's in truth, but on every single website that was in news form and in every single newspaper article, on CNN, on all the cable shows, there was full discussions about the jury, full discussions. And I'm not saying that that's exactly like what was said, but there is full discussions about the jury, so it wasn't in President Trump's truth.
Mr. Bove, do you want to speak to Mr. Blanche?
Yes, Your Honor. Thank you.
Defense counsel confer.
Thank you.
Thank you. I'm looking, Your Honor, and I'm happy to bring it up to the court and share it with the district attorney. I don't have a printed copy, but I can get one.
That's fine. Just let me know what it is.
Just to say what it is, it's a post from Jesse Waters from April 17th. It appears I'm looking at one that said 8:24 p.m., and it says verbatim, the same thing that President Trump said on his truth.
But that's 3 hours after your client's post.
Yes.
So it's irrelevant to that.
Well, it goes to...
There is no relevance to that. Do you have any case law that you want to hand up? Any other arguments that you want to make to me at this time?
Yes, again, Your Honor, we said it in our papers, but now that we've had this hearing, it's worth ending on this point, which is that this gag order, we are trying to comply with it, and there is no doubt that we are here about 10 different purported violations. President Trump is being very careful to comply with Your Honor's rules. And...
You, Mr. Blanche, you are losing all credibility. I have to tell you that right now. You are losing all credibility with the court. Is there any other argument that you want to make?
Yes, Your Honor. If anything, the reposts, and whether something can be reposted, an article written by a reporter can be reposted, and that is a violation of the gag order. That's ambiguous, and that's something that we certainly were not aware of. We don't read the gag order that way, and if that's the way that it's going to be enforced, we will take down the posts. Of course we will. And if we are directed to take down all of these posts, of course, we will comply. When you are thinking about criminal contempt and a willful violation beyond a reasonable doubt, it's important to look at, first of all, the first 3 posts that were the subject of the first order to show cause, which have nothing to do with those witnesses' testimony in this courtroom, and the reposts of articles that have been going on, for weeks. If that's a violation of the gag order, we didn't read it that way, and we will implement that and make sure that that doesn't happen. But certainly for all of the reasons that we've talked about, the president should not be held in contempt. If anything, the court should make crystal clear what it means with the reposts. And to the extent that Your Honor views the posts about Mr. Cohen and the system as being too close to the line, tell President Trump, tell me, and we will make sure that it's not violated.
As far as the whole distinction between reposts, you have stated it's ambiguous. You stated you didn't know. But again, I hate to come back to this, but you are not offering me anything to support your argument.
But Your Honor...
I was not done. You are not giving me anything to hang my hat on to say, yeah, you're right, the reposts, that was unambiguous, But as I've heard before, suppose someone outside has a placard, right? Someone outside is walking around with a placard and it says some horrible, horrible things. Is it your position that if your client were to grab that placard and walk around with it and it said terrible, terrible things about the jury, that he has done nothing wrong because he didn't write that post or he didn't write that placard, therefore he's absolved from any blame? Is that what you're saying?
It is nothing like what I'm saying, Your Honor. I'm saying this is a news article that's different than a guy walking around with a placard. And you said I offered no evidence, no argument to give Your Honor comfort about the case law. This has never happened before. There isn't case law. But here is what we did offer, and it matters, yo. Honor, there had been reposts, so we, of course, are trying to not willfully violate the court's orders. Okay? There are reposts that would appear to be similar to the ones that we are talking about today, and the people did not. We are not here because of those. And I agree with you, they have a choice. They can bring whatever they want, but that certainly goes to the willfulness.
All right. Look, if it's your position that there were reposts and the court didn't act on it and the people didn't act on it, you are absolutely right. But if it's your position that because of that somehow that's probative of anything, we are just going to have to disagree about that. The fact that the people did not come running in here immediately when your client started reposting things, or the court did not decide to summarily find your client in contempt, a decision that probably would have been overturned on appeal, is not probative of anything. You said, maybe we've gotten too close to the line. I think what you should have done is probably said, my client is thinking of reposting some things. It's not really clear to us in the gag order whether that's allowed. Judge Merchant, is that allowed? But that's not what you did.
Look, Your Honor.
So let's take our break. I'm going to reserve decision on this, and we will reconvene at 11 o'clock. I'm sorry, you wanted to say something?
Judge, if I may be heard just very briefly. Judge, first of all, and this is obvious, Michael Cohen and Stormy Daniels are not defendants in a criminal case. Mr. Trump is. He knows exactly what he's doing, Judge. I would like to just hand up one more truth. And if you could hand a copy to counsel as well, that would be great.
Handed.
And I think, Judge, the import of this is just that it illustrates what the defendant thinks about what happens when he posts something on Truth. It's a 2-page post. I'm just going to read it. It's from April 4th, 2024. One page. It appears one page of the post is about an hour earlier than the other on that day. But he's talking about his company, Truth Social, and he says, "But when I put out a statement or message," and I'm not sure what the distinction is in his mind, "it is spread all over the place, fast and furious. Everybody seems to get whatever I have to say, and quickly." So that's what we know about what the defendant thinks of his use of Truth Social. Judge, there is a lawful order here. It's very clear. The defendant has violated it willfully and knowingly by posting these posts. And we are asking the court to hold him in contempt.
Quick scheduling question, Judge.
Yes.
We're going to take a break until 11. Is it the court's intention to go from 11 to 2 straight?
Yes, it is.
All right.
All right. Thank you. See you later. All right. I'm sorry. Before you step out, I did receive your separate submission regarding the proposed limiting instruction as to the Wall Street Journal articles and the limiting instruction regarding AMI. The AMT limiting instruction that I came up with is really just a combination of the two. I took some from one and I took some from the other. The limiting instructions to the Wall Street Journal article, I basically adopted the defendant's version of this. I have made copies, and I will hand down copies when I come back at 11. Thank you.
Judge, one other thing. I said I would hand up a case, and I have a copy for the court, and I have a copy for counsel. Thank you.
Thank you.